right, Mr. Clark, this is Kenna with the Industrial Commission.
Who?
And Kenna. And,
Kenna. Okay.
Yeah, I just wanted to let you know that we did receive your fax.
Okay.
And so today I did a certificate of service and sent that over to Rachel Obar. And
okay, now I wanna kind of, I like to kind of like put something past you here, okay? If you don't mind.
Okay.
You know, I was looking how the Supreme Court and all this works, and how the judicial system works is actually what I'm looking into, because I didn't know government very well.
Right.
Okay, now because I happen to be reviewing a video that a Chief Justice had made in regards to how an appellant brought before the Supreme Court something involved based upon his injury, and had won his case, and it was sent back to the Industrial Commission for, you know, but now can you kind of tell me, like, how many injured workers have been before the Idaho Supreme Court in regards without an attorney?
Gosh, you know,
I really don't think very many. I think I could probably count them on one hand.
I don't know the statistics.
Well, because it's kind of odd that this Judge Bruddick, that made this video, it almost sounded like, and the way that I have been treated, especially from the clerk of the courts, not really being honest with me, I have a feeling that my case had been done. And nobody thought that I'd be doing this, what I'm doing right now. Because for the Supreme Court to make a decision right now, and then for the law firm of Anderson, Julian Hall to try to get me to settle during oral argument, or waiting for oral argument, things just aren't adding up, because Mr. Bruddick made that video in January of 2011. Now, you see, I think I've just caught on to something, and I'm floored on this, man. Because to me, and from everybody else that I've talked to prior, before I found that video the other night, they've never heard of an appellant ever making it to the Idaho Supreme Court without an attorney. You know, that's just their opinion, you see. But you see, again,
I know that there have been, because I've been involved in a few, but I really don't know how many.
Well, I just don't think there's been any of them since mine, unless there's, and then, well, anyway, things just didn't add up, and I didn't do what Steve Kenyon wanted me to do, so I think that's what kind of like set everybody back again this last time. Because he wanted me to, file for a new hearing, but I wouldn't do that, because I just knew he was up to no good, because he wouldn't be honest with me on some things that I was asking him. So, again, was that filed properly, ma'am?
Yes, we did. What we did is since on the bottom of your letter you said that that this was a new complaint.
Well, I'm not real sure what it is, ma'am. So let's I want to make sure that I'm doing this properly.
Well, what we did is we construed it as what we called an amended complaint.
Well, I'm not real sure if I want it construed as an amended complaint. Can you tell me what? Can you explain to me? Because I'm real edgy on when somebody redoes my filing for me, construed, as you guys presumed, as you guys are taking it. I amended a complaint.
If you can hang on just a minute.
You bet.
I don't have that right in front of me.
Okay, I'll wait.
I'm going to put you on hold for just a second. I'll be right back.
Oh, okay. Thank you, ma'am.
Thanks.
I need a cigarette.
Okay, thank you so much for holding.
You bet.
Okay, I just went and I've got your facts here in front of me. On the last paragraph on the first page, you said that you were filing a complaint of unpaid medical costs, transportation costs, etc. And so...
Well, on my first page, well, it may not be on the first page, because, again, I don't have mine in front of me. Okay, on the second page, let's see here, 1, 2. On the second page, or somewhere there, I believe that that it was it is being filed in relation to the remedy of the Idaho Supreme Court.
Okay, can I explain something to you? When this all started back in, what was it, 2008, it started with a complaint, and then we went through all this process, and you had your hearings here, and
No, wait a minute. Now, wait a minute. We need to make sure that we have the dates and the years in there on what,
Okay.
I filed a complaint,
Right.
June.
And we, and we went through, it's been several years, and you have the hearings here.
Well, what it was is I filed my complaint.
Well, now let me finish.
Okay, well, you're missing some things. Go ahead.
And I'm just kind of giving
Okay.
Just a short synopsis.
Okay.
And then when we issued our decision, and then it went to the Supreme Court, and they issued their decision and sent us the remediator. That was all based on that first complaint that you filed.
Well, that first complaint that I filed was dismissed because, as the attorneys reported in their filings, that since they paid me the money, which started the whole thing, when they paid it to me August 22nd of 2008 for the money that I wanted for that week that I was off when they fraudulently put me back to work, and from my understanding, that was dismissed by a letter also filed by this law firm of Anderson, Julian Hall, which stated that that my complaint was dismissed, and if I wanted to continue litigating my claim, I would have to follow the order of Mr. Donahue to sign these medical releases so they can actually have those documents in their possession legally.
Okay.
And then, since that was done, I had to file another complaint in November to continue my litigation, which was the part where the fraud comes in because the state insurance fund had received my documents without my authorization.
It was dismissed in November of 2008, and then another one brought it open, reopened it.
And that was the one that stated the state insurance fund had received my private health records.
Okay. Now,
is that right?
From that one is what, we had the hearings and so forth. And
well, I don't know what that hearing was for on November 17th because
everything that there's been a hearing on up to this point is what went to the Supreme Court, and the Supreme Court,
Well, then what was that went before the Supreme Court?
And so everything that you had a hearing on before.
No, that's not what I'm asking you, ma'am.
What are you asking me then?
Well, you're saying that everything that happened at the hearing. Well, was that hearing on my complaint?
On the complaint that you filed to get it all started, yes.
So my complaint. Now wait a minute.
All of the issues that were decided were in the Industrial Commission's decision, and then went on to the Supreme Court.
So basically, wait a minute. Let me make sure I'm right. So my complaint that I filed is what the hearing was based on, November 17th of 2010, was my complaint that I filed in November of 2009.
And whatever other issues came up.
Well, I didn't have any other issues, unless it's something my attorney threw in that I wasn't aware of, which I do have I did receive today a thing from the Idaho State Bar that there will be some kind of a review in regards to his ineffective assistance of counsel and the clear act of the violations that he did.
Okay, but that's nothing that the Industrial Commission.
Well, to me it is, because you all granted him the money, and I did file to have his lien also forwarded to the Supreme Court. Was that done?
I don't know. Whatever was forward to the Supreme Court, you would have gotten.
Well, I don't know, because I didn't get the proper. I don't know, because nobody wants to be honest with me. As you know, I'm not blaming you, but I feel that right now you're even, trying to cut some corners and not really answering. Was it my complaint that I filed in 2009 prior to hiring Lynn Luker, is because that's why I hired Lynn Luker, was in regards to my complaint.
Right. Well, let's get back to the document that you filed today.
And it's in regards to the remedy.
Right. And the reason that we said that it was an amended complaint is because everything has been taken care of up to this point through the Supreme Court. So
no, wait a minute. Does that? Oh, so you're trying to say that including my claim of 2006?
I'm going to keep talking, so I hope.
Okay, yeah, because you don't. Okay, go ahead.
Okay, so everything has been taken care of up to that point, and so if you filed this document today and you want to start something else start over, it has to be through the form of a complaint, and so that's why we called it an amended complaint.
Well, now. I'm not wanting to start over, because there's no starting over on my claim, because I have two, since you're in the legal department of the commission, your claim is separate than your complaint, because if you have a complaint against how the state insurance fund acted, you must file a separate.
It's the official paper that is called a workers' compensation complaint. That's what I'm calling a complaint, is the official paper, not your complaints about this and that and the other.
Well, I haven't filed nothing in regards to my claim. That was all done by my company. Now, because when I got injured, I didn't file any paperwork. I mean, I was off work. Everybody was paying the bills and everything until Carol Garland tried to put me back to work, which is with the state insurance fund, tried to put me back to work with some fraudulent job site evaluation that me nor my boss never received. So when I contacted the commission told me that I must file a separate complaint, and that's what I did. I filed a separate complaint about the state insurance fund's actions on my case. Now, not about my claim, because I haven't touched anything there. So, and then for Miss Rachel O'Barr to want me to, to write out some kind of a settlement offer that would include also the overpayment that they were rewarded back. Obviously something.
Now, the only thing that can be decided at the Industrial Commission is things about your actual claim. If you have problems with the way that you were treated by the state insurance fund, then that's something that you would have to take to the Department of Insurance to complain against the way they treated you.
Well, no, their actions. Their actions.
The commission can decide is about your actual claim for your injury at work.
No, that's not what it is, ma'am. I filed a complaint. The state insurance fund responded to that complaint.
Right.
Okay, and in that complaint that they responded to, they responded to the money that I was owed for the week that I was off because of the way they tried to put me back to work.
That has to deal with your claim.
No, that was my complaint. Okay, so you're telling me that I'm supposed to be finished? There's nothing more I can do? Because supposedly the way that everything was taken care of and the things... Well, so is that what you're telling me? Is that my case is over?
Well, what I'm saying is everything up to this point was dealt with the Supreme Court.
No, I don't believe so, ma'am.
And so I have...
Because you see...
I went ahead and sent your letter to Anderson, Julian Holt, because because I'm required to do that because they're still a party of the case, and they will have a chance to respond to that. And I really can't tell you what's going to happen beyond this point because I don't know.
Well, I'm letting you know that that I'll wait and see what paper and how you amended my complaint, which I will.
I didn't amend it all.
Well, I don't know who did, or the commission did, because they're trying to cover their tracks.
No, I didn't amend the complaint. I sent you a letter, and
they construed it.
We received your correspondence, your fax, and that we.
Well, now the way the remiter reads, the way the remiter reads.
To call it.
Okay, well then.
And then I sent you a copy.
Okay, did the commission receive? Okay, when from what I'm seeing, so was my case sent back to the commission back in 2011?
In 2011, back to the commission from where?
From the Supreme Court, supposedly.
No, we just barely got your.
Okay, the remedy of the Supreme
Right.
Court. You've already received that, correct?
Right, we got the remitter yesterday.
Okay, and now, in their opinion, in the opinion, I mean, I did have a couple of people look at that, and they were a little confused on it too, because when they first started reading it, they said, "Well, you won," and then as they started going back in further, they started scratching their heads. Now, in that opinion, they stated about the fraud that was committed by the state, that the Industrial Commission based their opinion or made their decision based upon fraudulent documents, affirm. So, and then it also reads that
what they affirmed is they're just affirming the decision that was issued by the Industrial Commission.
So the Industrial Commission confirmed that
the decision of the Industrial Commission was affirmed. So they're saying that they agree with the decision.
Okay, so you guys are gonna publish lies about me. Is that what you're saying? You're gonna continue to allow the statements that are in their findings of facts that are lies to be posted about me to continue?
That's just in the statute that is published every single.
Well, yeah. Well, it's published for public view.
Right.
Right. So the lies that they said that I fired Roger Brown, which I didn't, because I had the letter from the law firm stating otherwise, you guys are going to allow that to stay posted?
Well, anything that
No, it is.
Is posted. That's just what the statute says, is that it will be posted.
Well, then I will be coming to a lawsuit because it's a false statement. You guys have damaged me, and then when I spoke with my daughter in regards to, and so you guys are saying that the state fund did not commit fraud when they received my documents, and Mr. Donahue allowed it to go on. And for me to be lied to, stating that without these documents being signed, they couldn't receive these documents, but they'd already received them, and I wasn't given the opportunity to review these before they sent them out. Is that what you're saying? Is that what the commission's saying?
No, I'm not saying anything.
Well, I mean, aren't you the legal department?
I work in the legal department.
Well, I mean,
make decisions. I don't make the decisions. I just shuffle the paperwork and get them to the people that need to make those decisions.
Well, then maybe I worded it wrong, and so it doesn't get construed and filed a different way. Then tomorrow morning you'll be expecting it in regards to the way that I'm reading and my understanding of the remiter. Welcome to
file, and anything you file, I will send on to. Excuse me, I'm sorry.
Mm-hmm.
I'll send on to Rachel Obar and Alan Hull. I'm not the person who makes any decision. Depending on if they respond to this, if because if they should respond if it's an amended complaint, and we'll just kind of go from there. I don't know what will happen. Like I said, all I know is that everything up to this point has gone to the Supreme Court and came back. So.
Well, that's what I mean. I don't know what went before because.
Well, everything that went before would be in. We would have sent you and in fact we did. We sent you a record of everything that we sent to the Supreme Court, and then their opinion that came back. You also have, so. Including
the altered documents that even the firm even stated were altered after they went to the commission.
I can't respond to that because I don't know anything.
Well, I know because it's in the records, and what I don't understand too is I noticed that the law firm sent me a letter that was dated for September of 2013 in January of 2013. Now, why would that happen like that? And it was in regards to my motion for stay of all proceedings. Now,
I can't respond to that
either. Yeah, well, that's where I mean, and then for me not to be allowed to file anything in regards to the same way that everybody else was filing, but I had to file mine just directly through the mail, so I couldn't protect my documents from being altered or hand deliver them. Again, I still couldn't protect my documents once they were filed from being altered because, they're not, there's no way for me to show that they weren't altered because, I'm having to hand deliver them. So, okay, well,
we don't alter documents, so.
Oh, you don't white out documents before you send them back to people? I beg the difference because I have them here in my possession, in which I tried to show to the Supreme Court in my CD. But they were telling me, no, not at this time. If we need to review them, we'll ask for them. You see, I don't know how the video is that anybody else got, but I know what my video has, and it clearly showed that I tried to show these documents to the Supreme Court, and they wouldn't look at them. So.
Yeah, and I can't answer for that either. So.
Right, of course not. And you're not even answering anything in regards to what I'm needing to know with you in regards to Lynn Luker's that I had filed in regards to Lynn Luker's lien to be forwarded to the Supreme Court, which I have a document that shows that I did forward it to you all to be forwarded to the Supreme Court. Was that done? If I filed, yes, was part of the
record of what the Industrial Commission decision was on, then it would have gone to the Supreme Court. But if it was not in the Industrial Commission,
well, it was in one of their it was in the records already before the decision was even made. That was sent to me supposedly of the records of the agency's records, which would be you all, which is where Miss Wilson / Arnold is, well, I mean, she got to retire. I don't know where she's at, but she was. And then for my attorney to not have Miss Sandy Basket appear based upon my subpoena that I was granted by Mr. Donahue. You see, now, why was she not there? I want her arrested. She was not at the hearing that she was required to show by subpoena through the Industrial Commission.
I can't help you with that.
I know it well, but you're the legal department, ma'am.
No, I am just a person in the legal department, and like I said, I just handle paperwork and stuff, so forth. I don't make those decisions.
Well, I have a feeling that because the remitter that I have doesn't even have anybody's name on the bottom of it, because I went through all the other remitters online, and I noticed that the remitters always had, like Judge Brodick or whoever, wrote the, did whatever. But mine, it don't have it on the bottom. Mine just flat plain, because again, after reviewing that video that Mr. Brodick had put out on the air, that I was probably not to see, clearly, you know, because how many people have went to the Supreme Court from a workers' compensation and it was sent back to make sure that I was paid what I was entitled to based upon my injury. Now, boy, everything fit right to a T to me, in regards to me, because I almost feel that was pointed towards me. Because, you know, he did this video, and I might want to ask him that also, because, again, you know, why would he make a statement like that about somebody? And if and when I did look at when the oral arguments are, it doesn't show anywhere where oral arguments are in June. But that's when mine happened. So, because it gives the outlines of when the Supreme Court oral arguments are and when they hold them. And in that little time period of the June 5th, when mine was to be done, that wasn't the time for oral argument during that session of the legislation. So you see, things aren't adding up, and I'm catching on. So I'll just go ahead and let you go, and I'll wait for that letter, and I'll go ahead and switch around the first and the second page. So the second page is in the first page, so you all know that I'm responding in regards to the remitter that was mailed to me on September of 2013, and not whatever happened way back in whatever Mr. Bruddick was speaking about in regards to some injured worker that brought his case pro se before the Supreme Court and won. So I'll figure that out. But again, I'll wait and see what the law firm of Anderson, Julian Hall has to say. You know, so
yeah,
you know.
They, you know,
Yeah.
it did go out. It did go out in this morning's mail. So, you know, they're not even going to see it until next week. You know, depending on the mail, Monday or Tuesday. So
Okay.
we have to give them time to respond.
Okay. Thank you very much, ma'am.
All right.
Mm-hmm.